I'm going to try to talk to you about some aspects of EU regulations and EU member states regulation on two topics. The question of legal definition of certain spirits and certain types of alcohol, and the question of distribution law. Just be aware, we could spend several semesters talking about this subject alone. So this will be a very introductory presentation, and I won't be able to cover everything at all. So the first thing you have to know when you are importing a good, whatever it is, into the EU, is that this good must comply with EU regulations. And this is actually one of the duties of customs, to effectively check whether the goods imported into the EU complies with such regulation. This is important in the alcohol industry in general, because this is a heavily regulated environment, and the denominations, appellations of specific alcoholic products are defined legally. So two types of definitions at the national level and definitions at EU level. Just an important point, I'm a French lawyer, so I know EU law and I know French law. I have some ideas about legal systems in other European countries, but I'm not an expert in Belgium, Spanish, and so on. So just so you know from where I talk. So first of all, the legal definitions of alcohol at EU level, basically they concern spirits and wine. For the spirits, this couldn't at all fit into one slide, because there is a whole annex in a EU regulation of 2019 that defines each type of spirits and say, okay, this corresponds to that. You have to have this level of ABV. You have to use this kind of products, and so on and so on. So, for example, I gave here two examples, rum and gin. So you see that actually these definitions are quite classical. They correspond to the products you expect from these names. But I added, other criteria also. So there is a whole list below. For example, for rum, if I remember correctly, this was a huge question at the time, to know exactly about the level of sugar that was allowed in rum into the EU. And so I don't remember exactly how they decided, but this was finally decided. And so this is a real important issue to check whether your product that corresponds to a specific appellation in your home country can actually use the same appellation, or what appellation it can use when it's imported into the EU. One other point about the EU regulation and EU definition is wine. Well, I want to point out here that in the EU, wine is only the result of an alcoholic fermentation of grape. You cannot call a wine, and you cannot call an alcoholic beverage that results from the alcoholic fermentation of another fruit wine, which is historically nonsense, but it is still the case. And some people, even in France, that were not wine, for example, vin de noix, were sanctioned by the Fraud Administration. For other drinks, usually we look at national level. One example I give here is beer. And beer is, we could spend a few hours to talk about that, because there was a big case at the EU level where actually the legal definition of beer in Germany was quashed by the Court of Justice of the European Union, because it infringed the free movement of goods. But we won't deep into that. Just to note that, as you see, there is a French definition, there is a Spanish definition of beer, there is an Italian definition, a German definition, and so on. The definitions are usually very similar, but there may be some discrepancies. So when you are talking about a product that you are producing out of the EU and importing into the EU, you have to be aware that in that case, you have to comply with each national regulation. This is not the case if you produce it in the EU. You have only to comply with the national regulation of the production member state, and then you can export it throughout the EU. But if you are producing it outside of the EU, be aware of that. That is what I wanted to talk to you about legal definition. The second topic I want to talk to you about is distribution. This is a huge topic as well, and this is a topic that is both. It is a mix of EU and national regulations. The first thing that I want to look at is the EU impact of EU law on distribution. One very important aspect of it is EU competition law antitrust, because what we call vertical agreements, so agreements between a supplier and a distributor, or supplier and a purchaser, so people that are at different levels of the value chain in the distribution of a product. These agreements are to be analyzed possibly under EU competition law. And if your agreement is anti-competitive, you can face fines that can be quite heavy. Three things, for example, that are a no-no, to be basic. The first thing is resale price maintenance. When you are a supplier, you cannot tell to your distributor what is the level of the price that they can apply to end users or to their own clients generally. This is something that has always been considered an anti-competitive infringement, and what we see from recent years, it continues to be this basic competition law infringement that is always sanctioned by competition authorities throughout the EU. Second thing, you cannot prohibit to your distributor to sell to certain customer. So, for example, this can happen where you don't want, for example, for your product to appear in certain stores. Typically, this is the kind of things that, on principle, you are not allowed to do. You cannot say, okay, I don't want my products to appear on Lidl because it's not high-end enough. So that will be legal. There are exceptions. If you implement, for example, a certain type of distribution system, selective distribution system, exclusive distribution system, and so on. So there are ways to control how you distribute your products, but this is touchy, and this needs to be checked when you apply it. So the basic rule is do not control where your distributor actually sells your products. But if it's really important to you, this can be worked on. Finally, since you cannot prohibit your distributor to sell to certain persons or to certain clients, this is the same with online sales. You cannot prohibit your distributor to sell online if they want to, and possibly receive orders from people. For example, if you have a French distributor that sells online, they could receive orders from Italian clients or Spanish clients or Czech clients and so on. And that is something that, in principle, you are not allowed to prohibit. Again, there could be ways to control it a bit, but this is touchy and this needs to be reviewed carefully. So that's the thing about EU competition law. I really want to insist on it because it's something that is sometimes not considered relevant, because when you are a small company, you consider that this kind of body of law only applies to big companies. This is not necessarily the case, and this can be dangerous. Other thing, so there are also EU regulations that regulates relationship between distributors and suppliers. Hopefully for suppliers, this mainly tries to prohibit certain practices by big retailers, like big food retailers that combine their buying powers in European European purchasing bodies. And so normally this is something that protects suppliers. So for example, there is a limitation of payment terms, there is a prohibition of short notice termination, there is a prohibition of unilateral modification of contracts, etc. So this is something that normally protects you. So this is good. But if you are a distributor somewhere, please be aware of that as well. Finally, and then on distribution, there is a maze of regulations between member states. For example, when you sever a commercial relationship, some member states require you to provide a certain prior notice from a few months in certain countries where they say, okay, you can do whatever you want, but just be polite and say, okay, this will happen in 2-3 months. And some places like France where it is an appropriate duration depending on the duration of the total commercial relationship. And this can go up to 18 months. So this is important to note, and this is important to note that it depends on the law applicable to your contract. So you see France up to 18 months. Germany, when you have a contractual relationship for more than 5 years, then it's at least 6 months of prior notice, and so on. Depends each time on the member state you are talking about and which law is applicable to your contract. One point on France, because, French lawyer, so I have to talk about what I know. There is a big body of regulation on the process of negotiation of distribution contracts. Normally, this should not concern, importers because they have their own distributors on the French territory. But still, this is something to bear in mind because sometimes your distributors would want to just apply the same conditions that their own distributors apply and just have a back-to-back contract. So you have to be aware of that. There is body of law that provides for an annual negotiation of these types of contract. Normally, the supplier has to send its terms and conditions by the 1st of December for the next year, and the annual negotiation and the annual contract has to be signed on the 1st of March at the latest. And if it is not signed on this date, usually the distributor, but sometimes the supplier, can be fined. This is a financial sanction. So this includes the sales contract, so the price, the type of goods, the quantities, and so on. This applies also to possible services contracts you have with your distributors, and also logistics obligations. So, for example, logistics penalties in case of delays and so on. This is also, there is quite a huge framework. I'm not sure I have the time to continue. Okay. Also on France, there is what we call restrictive practices, practices restricting competition as compared to anti-competitive practices. So practices that restrict competition are things that are specific to France, certain types of behavior. So we've talked already about sudden termination of a commercial relationship, but others are also been into place. Some rules have been into place in order to protect commercial relationships and make sure that people are acting fairly. So, for example, there is a prohibition, and it is a possible ground for liability in case someone obtained an advantage without a counterpart. So, for example, you just say, okay, you give me this. For a recent example is you obtained this financial advantage from the government, so you give it to me. This was considered an advantage without a counterpart. The same is when you impose to your counterpart a contract which provides for a significant disequilibrium between the rights and obligations of the parties. Okay, a whole semester on this notion alone we could spend, but okay, this is the type of situation where it's also a negotiation tool. Okay, you say if you want to impose this, then I would have legal claim against you. So you need to modify this specific clause in your contract. There is also the question of logistic penalties, where there is a framework and a limitation of the amount of logistic penalties that can be imposed by distributors. And if they do not comply with it, this is also a ground for liability and a risk for fine. And finally, there is something a bit new, the case of discrimination, but not pure discrimination, and discrimination that implies to the counterpart, the parties that suffers from the discrimination, a disadvantage in the competition. So this is something very new. We don't have a lot of ideas about how it will be applied by courts, but this is a new arsenal in the negotiation stance between suppliers and distributors. So as you see, this is only example of France. We are particularly interested in regulating distribution relationships, I have to admit. So not all EU member states regulate in such an extent distribution relationships, but please note that this is only one example of a national regulation. So to try to summarize and to give some ideas, some behavioral recommendations. So 4 advices. 1, make sure your product corresponds to the local definition, that you use the correct name to your product. Avoid to control the sales of your distributors unless you have a grounded and legal opinion on the subject. When you are concluding a distribution agreement, check what law applies to this contract and to see whether there is a need for formalism and whether this specific law provides you with tools in the negotiation. And finally, in case of termination, check again the applicable law to your contract or to your relationship and see whether you need to provide a prior notice, or if you are on the other side, if you are the terminated party, you could see whether you have a possible claim for a sudden termination. So a lot of information, sorry about that, but I'm here after that and around in the salon if you want to ask questions after that.